even if the rules shift under us, this good faith effort to track where we're at will protect the integrity of the verdict. That's all I'm trying to do. So, they're ready. Oh, that's what I'm saying. They decide when they come out. So
They have not.
that sounds great. I've been there where I've said, bring them on out, and then somebody had just stepped to the restroom because all humans must step to the restroom. Mr. Rutherford, I need to point out that on page 7 of the charge you have in front of you, there's a charge on defendant's choice not to testify. As soon as you take the stand, I will be removing that from the charges because you have chosen to testify. All right, they may come on. And as we said yesterday, there's plenty of seats for all of you. You may sit wherever you would like. All right, you all may be seated. Welcome back to day 2, ladies and gentlemen. Like I said, as I started our trial, I told you I'd hoped that we would have finished last night. The trials are just what they are. They finish when they finish. As I said, there's no clock on the wall. I mean, there is, but there's no metaphorical clock on the wall. We will finish when we get done, but we are in the tail end of this case. So as you all will remember, as we finished out yesterday, let me get a couple odds and ends. If you have your phone out here with you, go ahead and pull it out and turn it off, make sure it's off. I also need to give you all a quick oath, so if you will keep your seats and raise your right hands. All right. Do you swear or affirm that you will try this issue formed upon this accusation between the state of Georgia and the defendant, Garrett Rutherford, and a true verdict give according to this evidence? And if you will, simply say, I will.
I believe.
All right, the jury is sworn. All right, so as you heard yesterday, the state rested. I had several housekeeping matters that were required to be done outside of your presence. I released you all. We finished all of those last night. And so we stayed a little bit later, got everything done, which actually turned out pretty well. So this morning, Mr. Rethford has the opportunity, but as you've heard me say countless times, no obligation to present any evidence in his defense. And if he chooses not to present evidence, then he will hear me direct you that you will not hold that against him. If he chooses to present evidence, then he will present evidence in the same manner as the state, where he may call witnesses. They'll be cross-examined by Assistant Solicitor Tony, and then we'll go through that process until we complete his case. And then we'll be on the very tail end with closing arguments and the charge. So, all right, Ms. Rutherford, do you wish to present any evidence?
Yes.
Do you wish to call yourself to testify or remain silent?
Myself.
Okay. If you will please come on up here to this stand. Ladies and gentlemen of the jury, up until this moment, all of the words that Mr. Rutherford has stated to you have been in his capacity acting as his own counsel. Therefore, nothing he has said to you at this point is evidence, nor, of course, is anything I ever say evidence or Ms. Tony's evidence. But from this moment, during the moment that he is in this seat, what he says from this point here is testimony. When he returns, I'm trying to give you all visible signals here. When he returns to his seat, the things that he says after that moment will not be evidence. Okay, you're all nodding at me that you're tracking this because this is really important. All right, Mr. Rutherford, raise your right hand. Do you solemnly swear or affirm the testimony that you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, take your hand down. State your full name for the record.
Garrett W. Rutherford.
All right, Mr. Rutherford, you may testify to the jury. If at any point there's an objection, just take a deep breath, let me sort that out, and then you may keep going with my directions. All right, the jury is yours.
Okay,
Use the microphone.
I think we left off yesterday with me stating that I do have a medical condition that causes nerve damage and causes my body to be off balance. But I do drive. And with that being said, I've been in this predicament before, and I did not submit to field sobriety test, and I end up with the same consequences. That's what brings us here today, because I'm going through the same thing again. So I'm here to present my medical records stating what my problem is, and that I'm really not driving under the influence. I'm driving in pain, still trying to perform daily duties and handle my responsibilities as a man. And me presenting my evidence, do I need to present these to the jury?
Show them to me first. Let's do this in just a very orderly way. So show me what you want to put in, and then we're going to have Ms. Tony walk up here in just a second.
Okay.
She's gonna get you some. Ms. Tony. Anything else?
Yes.
Or look at whatever.
That is my nerve study that's been conducted.
Your Honor, normally I would object because without a custodian to authenticate these records or testimony from someone to authenticate them, I would object on that ground. Given that I could cross-examine him on these records, the state has no objection.
Okay, what I'm gonna do, all right, so I'm gonna call this defense one. It's been tendered and admitted without objection from the state. I'm gonna take all of these documents and I'm gonna make them one single packet. So that will make this easier for all of us to keep up with. So what I'm gonna ask you to do is make certain as you use these. Now, you have other documents there that you did not hand me. Are you keeping those for yourself?
Yes.
Okay, well then do not include those in this packet, because Assistant Solicitor Tony has not had a chance to see those. So, okay, all right, then we're on track. You may continue your testimony.
Okay.
And the jury will have those during their deliberations.
Okay, and to proceed farther, with my next evidence would be saying this prior to today, I was injured by a DUI driver involved in a head-on collision. So I know what it's like to go through that situation and be hit by someone that is driving under the influence. That's why I don't put myself in a predicament to do the same thing to someone else. You know, don't get me wrong, I'm not here asking for no sympathy because right is right and wrong is wrong. I admit that I did, as the video showed, I did go out to get something to eat and have something to drink. But my reason for refusing to take a field sobriety test and a blood test is medical. So, you know, I'm just here hoping that you would take what I've said, what you have seen, and the evidence that we have amongst us into consideration in making a decision in this case. Thank you.
All right, so pull that mic up close. Hand me those exhibits back, or the exhibit back.
Oh, this.
That's okay. All right, Ms. Tony, since we, James, will you make an extra copy of this? Actually, let's do this. Let's give that to Ms. Tony. She can use the originals for a cross. As soon as she's finished, I'll get you to make an extra copy. All right, so Mr. Rutherford, what's going to happen at this moment is as soon as Ms. Tony gets her notes straight, she's going to ask you questions. Use that microphone, answer nice and loud so that the jury can hear what you're saying.
Okay.
And Ms. Tony, the floor is yours whenever you're ready.
Your Honor, do I have permission to mark this Defense Exhibit 1?
Yes.
Just for clarity.
Sorry, Donna, I stole your thunder on that one.
Your Honor, may we approach?
Yes.
Before I don't want to just start questioning from the jury without checking with you first. There are two statements that he made that opened the floor to his prior DUI, which was reduced for reckless conduct. One was him saying, I've been in this situation before with the same consequences. And the other statement was, I don't put myself in a predicament to do something else to someone because I was hurt in a drunk driving accident.
Yes.
All right, so the short answer is that the procedure, yes.
That's why we make this statement.
You
Yes.
hold that. All right, so my ruling is that Assistant Solicitor Tony made the right call as far as procedure, approaching the bench, asking for permission. Your permission to cross-examine on prior history is granted due to the opening of the door by the defendant with his statements during direct examination regarding his prior histories with cases similar to this, I believe was the statement. You may begin your cross.
So, Mr. Rutherford, you just told the jury that you wouldn't drive under the influence because you wouldn't want to put someone else in a dangerous situation. Is that correct?
Yes,
But indeed, you have been charged with DUI before, and that DUI charge was reduced to reckless driving, which you pled guilty to, correct?
I was not charged with a DUI. I wasn't driving under the influence that time neither.
That was in on January 24th of 2016
Correct, in Hampton, Georgia.
in Hampton, Georgia.
Correct.
And you were charged with DUI concentration of .08, correct?
No consent and no field sobriety test. That's was the issue.
Yes, it's true. You
But I
refused,
was not under the influence.
You refused field sobriety and blood tests then as well, right?
Yes.
That's right,
Yes.
and that's because you were charged with DUI.
No, because the officer smelled alcohol. Say he smelled alcohol.
So you were driving, and the officer smelled alcohol.
Yes, and I haven't been drinking. I
And
wasn't
you
drinking.
refused field sobriety,
Yes.
and you refused a blood test.
He didn't
Again.
ask for a blood test. No.
And was your license suspended as a result of that refusal?
No.
And you pled guilty to a reduced charge in that case, correct? To reckless driving.
No, I don't have reckless driving at all.
So it's your testimony that you did not plead guilty in 2016 to a reduced charge of reckless driving.
No, I did not. Do you
No.
have that? Do you have that to show? Do you have that to show?
Can I,
You may approach
I don't
further.
know if this will
That is exactly correct. You may
refresh your
approach.
recollection. So here's the date, January 24th, 2016. You were charged with DUI, driving under the influence, concentration of .08 grams by the Hampton Police Department. This is the disposition of the case. It says they reduced the charge to reckless driving, and you were found guilty, convicted.
Okay, so you have this. How would you have 0.8 grams of higher if there was nothing stated? That's why I said I wasn't under the influence. We have nothing stated.
Well,
I don't
Mr.
have
Rutherford, you testified that you refused the blood test, correct?
that. Yes.
And so could that be why the prosecutor agreed to reduce the charge to reckless driving, because you refused the alcohol
Well,
test?
we would have to speak with the attorney and the prosecutor on that case because I don't have that information.
In any event, you've acknowledged that you were pulled over, the officer
In the-
smelled alcohol, he asked you to do a blood test and a field sobriety test, and you refused. We can agree on those 5 points, right?
Yes, we can.
So you said that you get off balance when you drive because you've had a spinal injury, is that correct?
I have a spinal cord injury, yes.
Does the spinal injury cause you to go 31 miles per hour over the speed limit?
No, it does not.
And we can agree that going 31 miles per hour over the speed limit is an unsafe act, correct?
Yes, it is.
When did your injury occur?
The injury occurred in the first accident of 2/05/2011.
And do you take medication for this spinal injury?
As needed.
What is that medication?
I don't have it here to present it at this time.
So you don't know the name of the medication you
Not
take?
not right on.
Do you know what the medication does?
It relaxes my muscles, it calms my nerves, it relaxes the pain.
So it's a muscle relaxant.
I don't know what I can't tell you exactly what the name of it is. I don't have it here to present to you.
But it relaxes your muscles, is that right?
Yes,
And it helps with pain.
yes.
So were you taking that medication in February of 2022 at the time that you were pulled over?
No, I had been taking it, but at the time, no.
Okay, so the fact that you were on medication had nothing to do with anything in that traffic stop, is that right?
Can you repeat that again?
So medication had nothing to do with anything that you said or did during the traffic stop, is that fair?
Medication? No, I wasn't on any medication at that time.
Now your spinal injury wouldn't have affected a blood alcohol test, would it?
The spinal injury, it wouldn't affect the blood alcohol test, but it would show. Would it not show any prescription medicine in my bloodstream?
But you just testified that you weren't taking any prescription medicine at
At
the
that
time. Of the traffic stop.
at that time, no.
So a blood alcohol test wouldn't have been affected by your spinal injury, correct?
So how long does prescription medicine stays in your bloodstream? I'm I'm asking.
But I asked you the questions.
Please answer this
So,
question.
so what I'm hearing from
At
you,
the time, you're saying at the time of the traffic stop, was I taking medication? No, I was not taking medication at that time.
well, you seem concerned that you may have had prescription medicine in your system at the time of the traffic stop. I'm picking that vibe up from you. Am I wrong?
I understand what you're saying, but that's why I come back to say, how long does the medication stay in your system? At the time of the traffic stop, no, I wasn't taking. That would be that day. I'm not taking medication. I don't take the medication and drive. But if I had taken the medication 1 day or 2 days prior to that day, would that medication still be in my bloodstream?
Well, you're aware that medications like muscle relaxants and pain medications have a synergistic effect with alcohol, correct?
Yes,
Do the bottles of your medications say that you should not consume them with alcohol,
yes.
but you did anyway?
I wasn't taking it at that time.
You didn't raise anything about a medical condition when Trooper Clark asked you to do a blood alcohol test, did you?
Trooper, which trooper you saying? Can you repeat?
Trooper Clark, when he asked you, when he read you the implied consent and asked you if you would submit to a blood alcohol test, you didn't say anything about having a medical condition, did you?
If we go to the end of the video, you will hear me inform him that I do have a medical condition, which is a spinal injury.
But when you refused to take a blood test, you didn't say anything about your medical condition, did you?
I refuse to do the field sobriety test. That's it. In the video, it stated, I said there's no need.
Your spinal injury didn't cause you to have red, watery eyes on February 4th, 2022, did it?
Yes, it always caused me to have red eyes because I'm in pain.
Did your did your spinal injury cause you to reek of alcohol that day?
When you say reek,
Smell strongly of alcohol. Did your spinal condition cause you to smell strongly of alcohol?
no, a spinal injury wouldn't cause the smell of alcohol. But did he really smell alcohol? Who is there to say he really smelled alcohol?
Well, two separate troopers testified at length that you smelled strongly of alcohol. Isn't that right?
Yes, that's what we have.
and they noticed that you smelled of alcohol and asked you if you were drinking, and then you admitted you had been drinking, correct?
I stated that I was getting something to eat and I had 2 beers, yes.
And so you have no reason to suggest that they were making up that you smelled like alcohol when you outright admitted you had been drinking, do you?
Okay, well, what I'm saying is, okay, he said, I smell alcohol. I smell alcohol coming from the vehicle, coming from the person. Okay, that's why as I said, why didn't he search the vehicle? He said he was in pursuit of a black Suburban. He said I was going 77. He said I was going 86. So we have a whole lot of he said, they said. I said 2 beers. He said he smelled a whole bunch of alcohol. So do we base this off of facts or fiction? What's really true? He said.
Well, Mr. Rutherford, what's really true is that you had been drinking that day, correct?
Yes, I had 2
Okay.
beers.
There's no
Yes.
dispute about that.
No dispute about that.
And so you say that Troopers James and Clark were making this up even though you'd been drinking, and then you suggest that the officers in Hampton did the exact same thing, made up the fact that you smelled of alcohol. Had you been drinking that day too?
No, I have not.
So why did you refuse to take the blood alcohol test?
On which?
Well, let's start with the current DUI charge. Why did you refuse to take the blood alcohol test in this case?
In this case?
Yes.
Because of my injury. If I take a field sobriety test, they're gonna say he's off. He's
But I'm
a
talking
DUI.
about blood
They
alcohol.
they feel like or they think that I'm under the influence because he didn't pass the field sobriety test. So why do the physical field sobriety test when I know I'm not gonna pass?
I'm asking about the blood alcohol test. Why did you refuse to take that test?
I didn't refuse it. I refused the field sobriety test. That's the test that I refused.
Mr. Rutherford, did you see the video yesterday when Trooper Clark read you the implied consent
Yes.
card and
Yes.
afterward asked you to consent to a blood test? And you refused. Do you remember that?
No, maybe I didn't hear exactly what he said.
And so it's your testimony that you did not refuse a blood test.
I did not refuse a blood test.
But you're calling into credibility the testimony of 2 troopers today.
Repeat that again.
You're calling into question the credibility of 2 troopers today.
Yes.
I have nothing further, Your Honor.
Do you have anything you wish to tell the jury, Mr. Rutherford?
No, I don't.
You may return to your seat. Please take your documents with you. I believe Ms. Tony has the originals. If you'll just give those to Mr. Richards, he can go back into my office and make a couple copies. So Mr. Richards, if you'll bring back out 2 copies of that, because he'll get his originals back. 1 copy will go to Ms. Tony, and then we'll keep a copy up here. That will become State's Exhibit 1. Members of the jury, as I told you all earlier, I try to use physical space to help people understand things. So as of this moment, I'm officially stating on the record that the evidence from the words from Mr. Rutherford are closed. Any words he states from this point forward are in his role as an attorney representing himself. That's the evidence from the seat here. Okay. Mr. Rutherford, do you have any additional witnesses you wish to call?
No witnesses, Your Honor.
Do you have anything else to present?
No, Your Honor.
Okay, is it fair for me to say that you rest at this time, as in you have completed
Yes.
your presentation?
Yes.
Ms. Tony, you have the right to rebuttal. Do you wish to call any rebuttal witnesses?
No, Your Honor.
Okay. Therefore, the evidence is closed. So, as I said earlier, there are certain moments in the trial where I must ask you to step out, have a mandatory conversation with them. So what we're going to do at this point is we are at the very tail end of this case. So what's going to happen is y'all are going to step out for a few minutes, not when you're ready. Don't talk about the case or turn on your phones or anything. You won't be back there that long. I'm going to do a little bit of housekeeping with them. When you come back out, it is the most exciting and wonderful part of this trial. It's where I read the law to you. And it is just as boring as it is important. So I will also give you a copy of that law with you to have during your deliberations. So if you miss something, don't panic. But I am required to read it out loud to you. It takes about 15 minutes. Then you'll have closing arguments from each side. Ms. Tony has the right to go first and last. She may choose to go first or last or both. You'll hear me ask her that question there. We'll do closing, and then you will have this case. So I expect that you all will have this case within the hour to make your decisions on this case. With that said, if you will please step back into the jury room. Please knock loudly when you are ready. One for him, one for Miss Tony, and then one for Miss Donna. Yeah, exhibit.
I have the original copy.
Yeah, he gets the original.
I get the original.
Yeah, I'm okay with the court keeping copies. Okay, I am going to remove the section in my jury charges that says defendant's request. It says on page 7, defendant's choice not to testify. I'm removing that from these charges.
What page are we on?
Bottom of page 7, the second half of the page, I'm removing the part that says that you've invoked your right to remain silent.
Okay, yes.
So now what I'm doing is just resorting the pages, and then I'm going to print new copies for y'all. Ms. Tony, anything else before I hit print?
No, Your Honor.
All right, well then I'm going to put us in recess. I'm going to print these. If anybody needs to step to the restroom, do that. Are you going to want to go first, last, or both?
Last, Your Honor.
Okay, so what that means is, what's going to happen is as soon as I print this, I'm going to give you all a new copy. James is actually going to take up the copies you have. We've learned the hard way not to let too many floating copies of the charges get around, because then people quote the wrong one to the jury. So if you'll give those back, just the charges. Yeah, there you go. That one right there that you have in your left hand.
This one, okay.
All right, and those can be shredded. You can just go straight to the shredder. I'm gonna print the new ones right now. And again, when we come back out, I'm gonna read the charge to the jury. You will have a copy of my charge in your hand to follow along. You may use that in your closing if you wish to point to anything. Do either of you want a copy of the verdict form to use during your closing?
No, Your Honor.
No? Okay. Well, the verdict form is there, so if you want to, Ms. Margaret, will you make sure the document camera's on? If any of you all want to put it on the document camera and show things to the jury, feel free to do that. And I'll push it up to the screen if you decide you want to do that. All right, we're in recess just long enough for me to print this, give you 2 copies, sign it, and everybody step to the restroom. It's all right that they haven't knocked yet. All right, so let's come back to let's come back to order, everybody. I have up here, the verdict form. If either of you decide that you would like to use it in your closings, I'm just gonna leave it up here. You can walk up, I'll hand it to you. As far as the charge to the jury, you all have the updated version. We ran out of heavy-duty staples, so you have paper clips, I'm sorry. Neither of them are signed. I'm signing this one right now. It should be the version we just discussed. If you find any clerical errors or anything, let me know. And I'm signing it now. This will be the copy that goes out to the jury, and this will be the copy that goes to Carly with the verdict form when we're finished. If anybody needs anything else, Ms. Tony, anything else before we jump back in?
No, Your Honor.
Ms. Redford, anything else before we jump back in? Okay. Thanks for running tight of court today, by the way. I didn't say that earlier, but it's no secret that I appreciate folks who dress for church to come to court. It shows a respect that I'm grateful for. Okay. Miss Margaret, if you will, I don't want to rush them because they only have one bathroom back there. So if they need a little more time, that's great. But if they are ready, then we are too.
They're ready to.
They're ready? They come on out.
Come on.
Okay, remember y'all, I'm going to read the charges to them. Then Mr. Redford, you will close first. And then Ms. Tony will close, and then I'll have the case. All right, y'all stand up for me. All right, everybody may be seated. So, again, I detest sports analogies, but it's just so accurate, the baseball analogy for a trial, because again, there's no clock on the wall. It's just a series of events that occur. So I'm going to call this the seventh inning stretch. So you've had your seventh inning stretch. What we're going to do now is we're going to go straight to the end. So I am going to read you the law. This is the moment you've all been hoping, waiting, and dreaming for. It is as boring as it is important. I know you'll pay attention, but just in case you happen to miss something, you will have a copy of this with you in your deliberations. And each page is numbered and each line is numbered. That lets us be able to communicate clearly, and I'll give you instructions on how to do that when you have questions. I also have the verdict form, which I will go over with you so that you'll understand the questions on the table and the proper way to answer them. When I finish, we will do closings. Ms. Tony, are you going to want to go first, last, or both?
Last, Your Honor.
Okay, so then the order of events will be, I read you the law, Mr. Rutherford does his closing, Ms. Tony does her closing, and then you have the case. So 4 steps to the end. So with that said, the moment you've all been waiting for, I read you the law. Here we go. Charge to the jury, the state of Georgia versus Garrick Watavius Rutherford. State of Court of Spalding County, accusation 23 SR 487, accusation filed March 20th, 2023. You are considering the case of the state of Georgia versus Garrick Watavius Rutherford. The defendant in this case has been charged in an accusation filed by the Solicitor General of Spalding County with count 1, driving under the influence of alcohol, count 2, speeding violation, 86 and a 55, and count 3, window tint violation. I'm now going to read you the accusation in full. Accusation: Patrick M. Shepard, Solicitor General, State of Georgia, County of Spalding. Count 1. On behalf of the people of the State of Georgia, the undersigned, as prosecuting attorney for the county and state aforesaid, does hereby charge and accuse Garrick Watavius Rutherford with the offense of driving under the influence, for that the said accused in the county and state aforesaid, on or about the 4th day of February 2022, did unlawfully drive a moving vehicle while under the influence of alcohol to the extent it was less safe for him to drive. Count 2. The undersigned, as prosecuting attorney for the county and state aforesaid, does further charge and accuse Garrick Watavius Rutherford with the offense of speeding 86 and a 55, for that the said accused in the county and state aforesaid, on or about the 4th day of February 2022, did unlawfully operate a motor vehicle at 86 miles per hour on State Road 16 near West Poplar Street when the speed limit there was 55 miles per hour, in violation of OCGA sections 40-6-181, 40-6-182, 40-6-183. Count 3. The undersigned, as prosecuting attorney for the county and state aforesaid, does further charge and accuse Garrick Watavius Rethford with the offense of illegal window tint, for that the said accused in the county and state aforesaid, on or about the 4th day of February 2022, did unlawfully, having a material or glazing applied and fixed to the rear windshield or the side or door windows, which material and glazing reduced light transmission through the windshield or window to less than 32%. Contrary to the laws of the state, the good order, peace, and dignity thereof, Patrick M. Shepard, Solicitor General, Spalding County State Court. This accusation was filed with this court on March 20th of 2023. To this accusation, the defendant has entered a plea of not guilty, which appears on the face of the verdict. This accusation and the plea of not guilty form the issue which you have been selected, sworn, and impaneled to try. Presumption of innocence. A defendant is presumed to be innocent unless and until proven guilty. A defendant enters upon the trial of the case with a presumption of innocence in their favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. Proof beyond a reasonable doubt. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or prove evidence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. The reasonable doubt means just what it says. It is a reasonable doubt of a fair-minded, impartial juror honestly seeking the truth. Reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt which a reason can be given, arising from a consideration of the evidence, a lack of evidence, conflict of the evidence. After considering all the facts and circumstances in this case, if your minds are wavering or unsettled or unsatisfied, that is the doubt of the law and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Evidence. Your oath requires that you decide this case based upon the evidence. Evidence is how any fact that is put into issue is established or disproved. Evidence includes all the testimony of the witnesses, any exhibits admitted during the trial. Evidence does not include the accusation, the plea of not guilty, opening statements, closing arguments, nor questions asked. Direct and circumstantial evidence. Evidence may be either direct or circumstantial or both. In considering evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact. Circumstantial evidence is a proof of a set of facts and circumstances that tend to either prove or disprove another fact by inference. There's no legal difference in the weight that you give either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct or circumstantial or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. Credibility of the witnesses. You, the jury, must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their intelligence, their means and opportunity of knowing facts about which they testify, the nature about the facts which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. witness impeached. To impeach a witness is to show that that witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified to, or another way to talk about impeachment is that the credibility of the witness may be attacked by disproving the facts about which the witness has testified. Definition of a crime. The defendant is charged with a crime against the laws of this state. A crime is a violation of the law of this state in which there's a joint operation between act and intent. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided that you, the jury, believe that it existed from proven facts before you. It may be inferred from the proven circumstances of acts or conduct, and it may be, in your discretion, inferred when it is the natural and necessary consequences of an act. Whether or not you draw such an inference is a matter solely within your discretion. Now, criminal intent does not mean an intention to violate the law. It simply means an intent to commit the act which is prohibited by a law. No defendant will be presumed to have acted with criminal intent, but you may find such intention or the lack of it from a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act which the accused is being prosecuted. Strict liability offenses. Violation of Georgia statutes regarding moving traffic violations such as these are strict criminal liability offenses. With respect to strict criminal liability offenses, although it must be shown that the defendant intended to commit the act or omission which he is being held responsible, there is no requirement to prove that the defendant intended to commit the crime itself. DUI. Count 1, driving under the influence of alcohol, less safe. It shall be unlawful for any person while under the influence of alcohol to drive any moving vehicle anywhere in this state. The driver of a motor vehicle is under the influence of alcohol when that person is affected by alcohol to the extent that it is less safe for that person to drive than it would be if that person were not affected by alcohol. A driver who is less safe is less efficient, less skillful, less coherent, less able, less qualified, and less proficient. In deciding this issue, you may consider anything in the evidence that you find relevant in deciding whether the defendant was a less safe driver. Specifically, as to the consumption of alcohol, you may consider, among other factors, the smell or lack of smell of an alcoholic beverage on the defendant's breath or person. As to whether the defendant was less safe to drive, you may consider the factors that you deem relevant, including but not limited to the actual manner of driving the motor vehicle, the defendant's control of his mental and or physical abilities, the defendant's demeanor, the physical condition of the defendant, and any expert testimony. Merely showing that the defendant had been drinking or that there was a smell of alcohol on the defendant's breath or person without proof of the manner of driving or the ability to drive is insufficient to prove that the defendant was guilty of driving under the influence. Absence of a chemical blood test. The defendant's refusal to permit a blood test shall be admissible as evidence for the sole purpose of explaining the absence at trial of a chemical test and not as evidence of the defendant's guilt. Count 2, speeding, 86 and 55. Members of the jury, this accusation charges the defendant with speeding. As to that charge, I instruct you that no person shall drive a vehicle at a speed greater than the maximum speed set by action of the local governing authority. The accusation charges that the defendant did this by driving 86 miles an hour in a 55 mile an hour zone on Route 16 in Spalding County on February 2nd of 2022. The specific speed and speed limit are not essential elements of the accusation. That is, you are not required to find that the defendant drove that specific speed in that specific zone before convicting. Rather, the state is only required to prove that the defendant drove at a speed greater than the applicable speed limit on or about the date in question in Spalding County, Georgia. The speed limit may be established by official signs posted in accordance with Georgia law. Count 3, window tint violation. Members of the jury, it shall be unlawful for any person to operate a motor vehicle in this state which has material or glazing that is applied or affixed to the rear windshield or to the side windows, which material and glazing, when so applied or affixed, reduces light transmission through the windshield or window to less than 32%, plus or minus 3%. Venue. Members of the jury, the accusation alleges that each of the alleged offenses occurred here in Spalding County, Georgia. The location of the offense within Spalding County is an essential element of the offense and must be proven beyond a reasonable doubt by direct or circumstantial evidence or both. Date. Members of the jury, our law sets a time limit upon the state in starting prosecutions of most offenses. The defendant is on trial for a misdemeanor offense. Under Georgia law, the prosecution must begin with 2 years after the offense has been committed. In other words, the accusation in this case was filed with the clerk of court on March 20th of 2023. If you find from the evidence of the accusation that the case was not filed with the clerk of court within 2 years after the offense date, it would be your duty to acquit the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case, and you are bound by these instructions. It is your responsibility to determine the facts of the case from the evidence that's been presented to you. Then you must apply the law that I've given to you in this charge to the facts as you find them to be. Now, during your deliberations, you must shut off all electronic devices and leave them in the care with the bailiffs outside of the jury room until you complete your deliberations. You must not communicate with, receive any information from, or provide any information to anyone, by any means, anything about this case. You may not use any electronic device, including but not limited to tablets, cells, smartphone, computers, or anything that accesses the internet, nor communicate with anyone any information whatsoever about your case, nor conduct any research about this case until I accept your verdict. I cannot tell you how many trials have been ruined by these instructions not being followed. That's not in the charges. I'm just telling you how important that is. Sympathy. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws that I give you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. You should not be influenced by sympathy or prejudice because of race, creed, color, national origin, gender, sexual preference, local or remote residence, or economic status for or against any party. Implicit biases. More specifically, do not decide this case based on any implicit biases. Everyone, including me, has feelings, assumptions, perceptions, fears, stereotypes. These are called implicit biases, and we may not even be aware of these implicit biases. These hidden thoughts impact what we see and hear, how we remember what we saw and heard, and how we make important decisions. You are making very important decisions in this case, and I strongly encourage you to evaluate the evidence carefully. Resist jumping to conclusions based upon personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or biases. The law demands that you return a just verdict based solely on the evidence, on your evaluation of that evidence, your reason, your common sense, and these instructions. Our system of justice is counting on you to render a fair decision based upon the evidence, not implicit biases. You are only concerned, deliberation procedure. So you are only concerned with the guilt or innocence of the defendant. You are not to concern yourself with punishment. If after considering the testimony and the evidence presented to you, together with the charge of this court, if you should find and believe beyond a reasonable doubt that the defendant did commit the offense charged in a specific count as to the accusation, then you would be authorized to find the defendant guilty on that count. And in that event, the form of the verdict would be, we, the jury, find the defendant guilty as to that specific count. Count 2 of the verdict form, you will circle either the words not guilty or guilty, as you shall find. And then you will see on here that it's divided out into question 1 and question 2. So that's question 1 I just described. After finding the defendant, if you find the defendant guilty, you may, but you are not required to indicate the defendant's speed in the speed zone, only if you make unanimous findings of those questions. And you will see on to question 2 says, we, the jury, find that the defendant was traveling blank miles per hour, speed of the defendant, in a blank miles per hour speed zone. That is not mandatory. That's only if you choose to find a verdict on, if you choose to find a guilty verdict at a speed other than what is charged. Okay, and it says at the bottom, if no specific finding as to speed, then the court will accept the speed as charged. All right, that's count two. Again, speedings are a little bit weird because it's a two-part verdict if you choose the second. If you define the defendant not guilty of the speed violation, then you need not make any additional findings about the speed zone. It actually says work zone. I'm just going to cross that out and say, sorry. All right. All right. If you find the defendant not guilty as to the speed violation, you need not make any additional findings about the speed limit. If you do not believe that the defendant is guilty on a specific count, or if you have reasonable doubt as to that defendant's guilt as to that specific count, then it would be your duty to acquit the defendant as to that specific count. In which event the form of your verdict would be, we the jury find the defendant not guilty, and you would circle not guilty next to each of the three highlighted counts that I've put here on the verdict form. The accusation has the verdict form, which is attached to the front, and it has a place for you to indicate your verdict as we go. Each of the your foreperson will circle not guilty or guilty as you shall unanimously find. Whatever your verdict is, it must be unanimous. That is agreed by all six of you. The verdict must be signed by one of your members as foreperson, dated and returned and published in open court. Please make sure your verdict is in ink, not pencil. One of your first duties in the jury room will be to select your act as foreperson. Actually, I'm going to stop at that point. And I'll read the last little bit once closing statements are concluded. So, all right, so at this point, I've got just another page to read, but I'm going to save those last instructions until we're finished. So what we're going to do at this point is Ms. Tony has waived the right to the first closing. So Mr. Rutherford at this point is going to give you your closing argument. Once he finishes, Ms. Tony will give her closing. I'll finish up the last page, and then you all will have this case.
I have no closing argument.
Okay. All right. As you've heard me say on multiple occasions, opening, closings, those can all be waived by the attorneys. It's not an entirely uncommon event. And so therefore, Ms. Tony, the floor is yours.
Thank you, Your Honor. Ladies and gentlemen, I want to start talking with you briefly about venue, speeding, and window tint. And then we'll move on to the core of the case, the DUI. First of all, venue, you heard Trooper James and Trooper Clark both testify that the traffic stop, the driving occurred in Spalding County. That's why I asked them those questions several times. And so the state has proved venue. With respect to speeding, the troopers testified about the process by which they assess speed. If they see a car coming that they think might be speeding, they do an eyeball estimation of how fast the car is going. Here, the troopers testified that the estimation, eyeball assessment was that the defendant was going 77 miles per hour. Trooper James then used his radar to determine the actual speed, which turned out to be 86. The state believes that based on this evidence, plus Trooper James' testimony that the posted limit was 55, that the state has proved the speeding violation. With respect to window tint, you guys were able to see almost all of that evidence on the body cam. First of all, I don't know if you noticed when Trooper James rolled down the driver's side window. That window was opaque black, very, very dark. Trooper James explained that there was an issue with the window tint. You saw him on body cam conduct the test, explaining the steps to the defendant and showing him the result. It was 2%, which is clearly in violation of the statute. So the state submits that we have proved the window tint violation. So on to DUI. I want to start with the law on DUI. So the state has to prove, I'm going to sort of summarize OCGA 46 through 391 for you. A person shall not drive any moving vehicle while under the influence of alcohol to the extent that person to drive. And so as you analyze the evidence that you've received in this case, it's helpful to kind of look at it in this framework. So we're going to start with a person. Obviously, that's the defendant. He's a person, shall not drive. Trooper James testified that he saw the defendant driving the car. And that car was a Chevy Silverado pickup. That was a moving vehicle. You saw him pull the vehicle over in the body cam. Under the influence of alcohol, the defendant admitted he had been drinking. He admitted that he was at a Mexican restaurant. He drank 2 drinks. He refused to tell the officers what size those drinks were or specifically what they were, but he admitted drinking. He was under the influence. Other evidence that he was under the influence: red, watery eyes, slurred speech, also go to that point. We also have the fact that 2 separate officers, trained officers, people who have worked on a DUI task force, understand DUIs, both in their separate assessments determined that he was less safe to drive. That is evidence that he was less safe. And finally, this one. It's less safe for the person to drive. He was speeding. He was going 31 miles per hour over the speed limit. And the defendant admitted on the stand that that was an unsafe act. Going 31 over the speed limit, reeking of alcohol, red eyes, watery eyes, slurred speech, the testimony of 2 separate troopers, we submit that that is evidence for the state to overcome their burden. Notice that nowhere on this list does it say that the state has to show a blood alcohol level, nor could we have in this case because the defendant refused to submit to that testing. I just want to talk briefly about credibility. The defendant attacked the credibility of these 2 troopers. You saw them on the stand, you saw their testimony, you saw their demeanor, you saw the way they conducted the traffic stop in the body cam. I will let you assess the credibility of the 2 officers. But the defendant's credibility is what I would like to talk about. He testified that he would never drive impaired to you on the stand. And then we found out, no, he actually has been charged with DUI before, and he refused those tests as well. It seems like he drives impaired and then refuses the test and then thinks he's going to get out of it in some kind of gotcha. And finally, you saw the body cam, you saw Trooper Clark read him the implied consent and request for him to submit to a blood test, and the defendant clearly refused that blood test. And yet he testified on the stand today that that never happened. He would have you believe his testimony here on the stand rather than what you witnessed on the body cam. And I submit to you that that deprives the defendant of any credibility about the truth of these charges. It's up for you to decide whether it's acceptable to go to a restaurant, drink at least 2 drinks, and then speed down a Spalding County road at 31 miles per hour over the speed limit. I submit to you that doing that makes someone a less safe driver under the influence of alcohol, and I ask you to return a verdict of guilty. Thank you for your time. We appreciate your service.
All right, thank you, Ms. Tony. Okay. Members of the jury, in picking up and finalizing my instructions to you, here are your deliberations, the final part of your deliberations instructions. One of your first duties when you enter the jury room will be to select one of you to act as your foreperson. Your foreperson will preside over your deliberations and who will sign the verdict to which all 6 of you have freely and voluntarily agreed. You must make fully independent and separate decisions of either not guilty or guilty for each of the counts regarding the defendant in this trial. You should start your deliberations with an open mind. You should consult with each other and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussion and consideration of your case with your fellow jurors. Do not hesitate to change an opinion that if you are convinced it is wrong, but never surrender an honest opinion to be congenial or simply to reach a verdict because of the opinion of other jurors. By no ruling or comment which the court has made during the progress of this trial has the court intended to express any opinion upon the facts of this case, the credibility of the witnesses, the evidence, the guilt or innocence of the defendant. The court's sole interest is this case be tried fairly in accordance with the law. Once you have reached your verdict on each count, you will notify the bailiff. I will bring you out into the jury box, identify your foreperson, ask your foreperson just a couple of basic questions. A, have you reached a unanimous verdict? If the answer is yes, have you reached your verdict and have you filled out the form properly? If the answers are yes, your foreperson will give the verdict to the bailiff, who will pass it up to me. I will review it to ensure that it is in proper form before I read it out to the jury myself. If you have any questions, I meant to include this in the directions. I'll add it to the next round. If you have any questions, you have your notepads. Simply have your foreperson write out a written question on it, sign it, date it as your foreperson, and pass it out to the bailiffs. They will give it to me, and to the best of my abilities, I will answer any questions you may have. You will have all four exhibits back in, all four of the state's exhibit plus the defense exhibit with you. Two of them, of course, are videos. You do not have the capabilities because I cannot give that back to you in the jury room to watch videos. So if you do need to watch the videos again, write out, we would like to watch X, Y, or Z. I'll bring you back out. We will simply quietly watch it and then I'll send you back in. So I just want to make certain you know you have that option if you choose to. So with that said, you may now retire to the jury room. Do not begin your deliberations until the following steps have occurred. You have delivered all of your phones in a shutdown way to Miss Margaret Yarborough, who will protect them with her life. The bailiffs will then have delivered to you this verdict form with the accusation attached, the evidence that has been admitted in this case, and this copy of the charges. You may go to the jury room at this time. I need to get y'all a nice box that says jurors' phones.
Did she get all that?
Not yet. They just walked out. I can give you this though. All right, jury's out, doors closed. Miss Yarborough has a box of phones. Again, I just find the phones are too tempting to have back there during this high stress moment. Well, hold on, let them bless it before it goes out, but you're almost ready. So, Ms. Tony, Mr. Rutherford, if you'll please look at the documents that Mr. Richards has, make sure everything is in proper form before it goes out. I have to have them bless it.
What we have here.
So it should be 4 state's exhibits,
Just
1 defense
probably
exhibit,
video, huh?
jury charges, and the verdict form.
Yeah. Yeah, and we already reviewed that. We just went over.
Right.
Yeah.
Charge sheet.
These are the evidence that I presented, yeah.
That should, if I've done my job right, that should be everything.
Oh, two, yep, that's correct.
Okay. All right. Both the state and the defense have agreed that the verdict form, the charges, and the exhibits may go out to the jury. Any exceptions to my charges, Ms. Tony?
No, Your Honor.
Any exceptions, Mr. Rutherford?
No, Your Honor.
All right. Then I'm gonna put us in recess. If anybody has anything, or if the jury has any questions, we'll reconvene. And again, if the jury wants to watch it, they write out what they want, they come out, I play it. Actually, I don't know that I can play it from here. We might have to have y'all play it. I can play it, but the sound doesn't come through from this computer out. I can only put up video. So, yeah, that'll work. Okay, well, if we get to it, that's it. You're good to go, Ms. Yarborough? So what we're gonna do is, with this case specifically, what we're about to do is we're gonna bring when the jurors are ready, we'll bring them back out. We'll identify the foreperson. I will ask the foreperson, are you the foreperson? Do you have a verdict? Is it unanimous? And have you filled it out in pen, not pencil? If the answers are yes, yes, and yes, I'll have them give the form to Ms. Yarborough. She'll hand it up to me. I'll make certain it's in proper form, and then I'll read it. We've had situations where they fill it out wonky, and I always want to check that before it's read out loud. As soon as they've read the verdict, I will thank them for their service. I will ask you all if you have anything else you would like to address before I release the verdict to the jury, and then I will cut them loose with thanks of the court and pass them off to Carly in case they need a letter or anything. On a bigger level, since Mr. Shepherd's in here, that means we're about to finish here. I'd like to move the camera cases up to here for this afternoon because magistrate had already reserved that courtroom for their court. And the Tuesday start is the only reason this is an issue.
I think y'all all already told me.
They already told it, Jesse already got that lined up now.
Come up here.
Okay. Any housekeeping before I bring out the jury?
No, Your Honor.
Any housekeeping?
Yes.
All right, if the jury is ready, they may come on it.
Are y'all ready?
All right, Mr. Worthen, I saw that you were holding the paperwork. Does that make you the foreperson? You may have a seat. All right, if you'll stand up for me, I have just a couple of questions, and then I'll take the verdict form from you. Are you the foreperson?
Yes, sir.
All right, and have you all reached a verdict?
Yes, sir.
Is it unanimous?
Yes, sir.
And have you reached a verdict on all counts?
Yes, sir.
And have you filled it out in pen, not pencil?
Yes, sir.
I know, it sounds silly, but we make rules when things happen. So, all right, then if you will pass the verdict form to Ms. Yarborough, I'll review it, and you may have a seat. As soon as I confirm it's in proper order, I will read it. All right, everything is in proper order, so good job on the procedural side of it. All right, the verdict reads as follows. As to count one, we, the jury, find Garrett Watavius Rutherford guilty. As to count two, as to the charge of speeding, we, the jury, find the defendant guilty. There is no answer on question number 2 as to count 2, which means I will accept the verdict at the original speed of glasses. 86 and a 55. As to count 3, we, the jury, find the defendant guilty. Dated the 13th of November, 2024. Foreperson. Y'all both come up here, take a look at this. There you go. You're looking for the form of the verdict, like, is there anything that looks wonky about it that I missed? It's not necessarily that you agree with it. You say, no, it's not what you wanted, but. All right, no objection to the form of the verdict. Okay, so there's no objections to the form of the verdict. Ms. Tony, anything else before I release the jury?
No, Your Honor.
Anything else before I release the jury?
No.
All right. So, members of the jury, that concludes your service on this case and for the week. I want to say thank you for being here. Again, before COVID, we would say things like, I can't imagine what it's like to not be able to have jurors here. But now we all know what it's like, which is that cases get stacked up. People cannot get it. It's going to take us years, frankly, to clean out cases. I mean, you just saw the dates on here that we're still trying cases from 2022. And frankly, we're ahead of a lot of other courts and we still have a long way to go. So I just want to thank you for coming in. Again, you all, some of you I know and some of you I don't, but I just want to say thank you again for frankly answering the call. You gave up your lives and you have work or home where you have team members or family members who are giving up their stuff to cover for you while you're here. And I just want to make certain you hear us all say thank you. And please tell them, the court and all of our team members, say thank you, because without y'all here, we can't resolve cases like this. And so I also release you from your oath of silence. So that means that from this point forward, you can talk to everyone, or no one. It's totally your decision. So if you don't ever want to talk about it again, don't do it. If you want to talk, because again, the state may approach you, or the state, it's common for the attorneys on both sides to ask you questions about what you thought or whatnot. I also would love your opinion. We have worked very hard as a state court team to create a jury service system that is the most respectful of your time as possible, including knocking down walls and putting in new carpet. So you're the very first jury to use our new jury room. Before that, it was a tiny room where you had two concentric circles to sit around, and even 6 people at the table was very tight and very uncomfortable. So we're so excited about that new room because we do have a lot of 12-person juries here. Any questions I can answer for you all before we part ways? Okay, keep your badges. Those are our gift to you. Just if you come back to the courthouse, don't wear them. That will confuse the next round of everybody. But those are just a token of just saying thanks. You can throw it in a drawer and remember fondly your time that you spent here with us. So you can now have your phones back. Miss Margaret has set them there on the chair. So as you go back in, just grab your phone, just yours, and go grab all of your things. Leave your notepads face down. They will go straight into the shredder. Everything else in that bag is yours to keep. So leave the notepads, everything else keep. And if anybody needs a note, you want me to send them to the first floor? Okay, if anybody needs a note from your employer, it goes to the first floor to the clerk's office. Okay, y'all, thank you. And you can come straight out and straight across. Okay, Mr. Rutherford, what I was trying to do was have you go ahead and meet with sentence enforcement, but they cannot meet with you effectively until I pronounce the sentence or until they get a recommendation from the state. Well, this is a jury trial, there's no recommendation. So we had a bit of a cart and a horse issue. They cannot meet with you until I sentence you. And so, so what we're going to do is I'm going to hear from the state first, and then I'm going to hear from you. And what I'm hearing from you is whether or not, or what an appropriate sentence on this case should be. And then I will decide the sentence from there. Do you understand what we're doing next? The jury's found you guilty, so it's my
Yes, yes.
responsibility to sentence you.
Yes.
And so Ms. Tony is going to have an opportunity to state what she thinks the state's position should be as to what the sentence could be. The maximum sentence allowed by law is 36 months to serve in the Spalding County Jail for 3 misdemeanors at 12 months each. And then, of course, all the probation conditions that we would normally do for anything less than that. So, okay. Ms. Tony, I'll hear from you first as to recommendations for the court for sentencing.
Your Honor, the state asks for 10 days in jail and 36 months probation, given that this is his, sort of his second and 10, because he had one that was reduced in 2016. He also had a reckless in 2002. I don't know if that was a reduced charge, but based on his history, we would ask for 10 days in jail and 36 months of probation.
Okay. Mr. Rutherford, if you could choose my sentence on this issue, what would you choose?
Say that again.
So obviously the jury's found you guilty, which means it's my responsibility to sentence you. And so I have a very wide discretion in what I think the sentence should be. And this is the moment for you to say, well, Judge Thacker, I think the sentence needs to be this. And I know that's a very technical question, but it's the question I have to ask you at this moment. And frankly, if you had an attorney, your attorney
Yes,
actually
you know,
would already
she-
have an
she-
answer
She
ready.
think it should be one thing, you think it should be another thing, and you want me to think it should be something else.
Sure. Yes, that's exactly right.
Okay.
That's a very good way to put it.
First of all, let me ask, what is the usual sentence?
No, you don't get to ask me questions. I get to ask
Yeah.
you questions. Sorry about that. I mean, I understand why you asked that, but the answer is I'm not
Okay.
gonna give you that.
Okay, I think that the sentencing should be 12 months on probation, 10 days in jail. Because, transportation, my age, having to try to depend on somebody to take you back and forth, report, things like that, you know what I mean? That's a downfall. So, I'm putting myself in a rock and hard place. All this probation, trying to report, getting there, it's kind of seemed like a setup of failure to me.
Okay. All right, that's a reasonable response. Good response, Mr. Rutherford. And I just want to commend you, by the way. A lot of times we get defendants in here who frankly don't dress appropriately for court, and their arguments are nonsensical and not logical. I think you did a great job representing yourself. I thought you tried the case well. I think you've tried it better than some attorneys that have come in here. And so I just want to commend you for your demeanor. I'm grateful for the respect that you showed to the jury and how you interacted with them. I thought your questions were probative and appropriate. And I just wanted to acknowledge to you that that was not lost on me and that is factoring into my decision, that I understand why we tried this case. I didn't think this was a waste of the court's time. Some trials, at the end of it, I wonder what we just did and why we did it. I do not feel that way about your trial.
Yes.
And I feel very strongly that your request for a jury trial in this case is exactly the kind of case we should be trying in this courtroom.
Yes.
So, and Ms. Tony, I think you've done a great job. I know this was your, you finally got your sea legs in here, and after a long career in other areas. So, all right. Anything else, Ms. Tony, before we jump in?
No, Your Honor.
Anything else, Mr. Rutherford?
No, Your Honor.
Okay. All right. Follow me to the end of what I'm about to say. So the sentence of the court, the jury has found you guilty. It is my responsibility to sentence you. The sentence of the court is as follows. As to the DUI charge, guilty, 12 months, 2076 is your fine. Count two, speeding, 86 and 55. Guilty, 12 months consecutive, 1425 is your fine. Count three, window tint violation, guilty, 12 months consecutive, 742.50 is your fine. Do you still own that vehicle?
Yes,
Have you removed the window tint?
yes,
Okay, so I'm gonna write down here, must show proof that window tint is corrected. Okay, so that's a total of 36 months of probation. It is 10 days to serve in the Spalding County Jail. You will reobtain your Georgia driver's license and you will show that to sentence enforcement. You will have no alcohol, illegal drugs, or hemp products, and you'll be tested for those. You will be subject to random screens. You will waive any evidentiary foundations for admissibility of drug testing and alcohol testing. You will have a $60 per month supervision fee. You'll have a one-time $50 intake fee. In this case will be a no early termination case. This will also be consecutive to any state court sentence, if any. This probation may go to e-report after completion of all terms and 18 months. This may go to non-report after completion of all terms and 24 months. Your jail time will be served instantly. So Piper will be transporting you at the conclusion of this to the jail. You will do 40 hours of community service work. You will complete a substance abuse evaluation within 90 days. You'll complete a DUI school. I was going to order AA, but I think what I'll do instead is you're going to do a substance abuse evaluation. I think that I will I think I'll hold off on that and let them decide what they're going to do. You should know that this was not the sentence I was originally considering, but frankly, given your demeanor, the respect you had for this court, and I just do need to say out loud that I did look you up in my system, and this is your 36th case in my system since 2002. No, excuse me, 2001. So, I mean, you have had a lot of cases with this court or with this court system. Some of these are felonies, but it doesn't look like you got convicted. You were convicted of any of these felonies. Am I correct on that? There's no felony conviction in your history? Okay. And it looks like all your DUIs were successfully reduced to other things or dismissed. Is that also correct? You have no previous DUI convictions? Because I show several previous DUIs.
no,
No, okay.
no.
So no previous convictions, no previous felony convictions, I'm sorry, no previous DUI convictions, no previous felony convictions. But you have had 36 cases with me or with the court system here. So again, my original sentence was frankly going to be much harsher than that. But because of your actions, your demeanor, the way you conducted yourself in this courtroom, I added things like that you may go to e-report and that you may go to non-report after a certain amount of time. I also reduced my initial incarnation of 30 days to serve down to 10. So I'm just letting you know that this is what you're seeing, but what you're not seeing is where I started and how you brought those things down through your actions. And Ms. Tony, is there anything else I need to address on here that I have not addressed?
No, Your Honor.
Mr. Rutherford, do you have any questions for me before I adjourn?
Yes, can we go over those prices again? And I would like to know, how does the price change now that we're at the end of trial?
Well, it didn't change. That's what I need you to know. How to explain this? Okay, you ready?
Yeah.
I am think of me as the stable spot off in the distance. I am I hate this analogy, but I'll find a better one someday. I'm the manufacturer's suggested retail price. So I'm the fixed point up here. All negotiations that you had, all discussions that you had,
Yes, yes.
those are all things to avoid this trial and to avoid
Yes.
this thing. So I didn't change anything except I moved things in your direction. So that's why the numbers are what they are, because those are my numbers. I didn't even ask what y'all negotiated because I didn't care. What you all worked out that didn't happen is irrelevant to me at this point. So does that help you understand that these numbers are not what you thought they were going to be? Because
Yes,
frankly, these are my
that's
numbers.
Yeah, that's out the one, yeah.
Okay, so that's the answer to your question. The answer to your question is, I don't know what numbers you had before this, and I don't care about what numbers you had before this, because these are my numbers, and this is my sentence, regardless of what y'all had negotiated, because that was not taken, and therefore y'all handed it to me to sort out.
Yes.
Okay, that's a good question. I hope I gave you an answer that makes sense. So, all right, Ms. Rosario, you may come on up.
I have
Piper,
one
as soon as-
more.
Okay,
I have one more question, with during my time immediately, is it possible for me to change my clothes, or how does that work?
Nope, you can go just like that.
yeah, you can go like that. It's gonna be okay.
If you got somebody to turn like your wallet and stuff over to, you
Yeah.
can do that. But
Do you have anybody here that you can give your stuff to?
Yes, yes.
Okay, I thought you were here with him.
Yeah,
So, and hey, you're gonna get credit for any time you served. Don't forget that. So I put 10 on the sheet, but don't forget, you get credit for what you've served.
so how does that calculate?
It's up to the sheriff. I don't have any control over that, but I just wanted to let you know that I'm giving you credit for it.
Okay,
And just remember, if you conduct yourself the way you've conducted yourself in this courtroom with probation,
Yes.
you're not going to have a single issue with probation. Because again, my goal is to give you an exit ramp that's solid and reliable. So, all right, with that said, this matter is now adjourned. Deputy Piper, if you'll transport, Ms. Rosario, he's all yours to meet with.
can you take these off for a second?
You did.
All right,
Yeah, thank you.
I'm gonna step off the bench.
People
Y'all let me know when
take
you're
a
finished, I'll come back out and we'll adjourn.
you gonna take your jacket off?
Okay, I can just adjourn from here?
Yeah, I don't think.
Okay. All right, everybody, that concludes the trial calendar.